Intention to create legal relations is probably one a lot of people get sort of mixed up with. It's really quite straightforward, to be fair. It's about whether the parties want their agreements in the beginning when they're negotiating for it to be legally binding. And there are generally two types of agreements. So the first one is social and domestic agreements. So for example, between friends, family, neighbours. There is a rebuttable presumption that these are not legally binding. Okay, so what we mean by rebuttable is the opposite can be proven in certain circumstances. Now Balfour and Balfour, Jones and Pemberton, they're good cases. Balfour and Balfour, that's sort of within a marriage, a promise made within a marriage, was not legally binding. In certain circumstances they can be though. So of course, if you prove on the circumstances or on the facts that you probably did intend it to be legally binding, then it can be. So for example, you've got contracts like prenuptial agreements, haven't you, where during divorce settlements. But merit to merit was a promise made when the couple had already split up. So the difference, even though they were married, they'd split up and they were making arrangements to move away from each other and move on. In that case, you got the argument that it was they meant for their agreements to be legally binding. Now that first one is usually what the problem questions are sort of focused on. It's usually two people who sort of know each other in some way, and you're expected to discuss they have a social and domestic agreement. You explain what it is and then you apply it, of course. It's very unusual to see commercial and business agreements because where that happens, you're going to be using the Consumer Rights Act, and so the problem will not generally be about intention to create legal relations. That's rather assumed because any implied rights mean there is automatically legal relations. Now for completion though, it is a rebuttable presumption in certain circumstances that it is legally binding, but in certain circumstances it won't be. So like betting on pools, for example, where it's a gentleman's agreement or binding in honour only, that does not mean much. Now there is a halfway house as well. So if two people know each other but it looks more like a business agreement, then you may follow Sadler and Reynolds, in which a journalist was contracted to ghostwrite a memoir for a politician. Now that's a business agreement even though they knew each other.